कॉन्स्टिट्यूशन हा माझा स्पेशलायझेशनचा विषय नाही हे आपल्याला सगळ्यांना माझी ओळख करून दिली तेव्हाच समजलेलं असेल. मिलिंदचं म्हणणं होतं जेंडर कंपोजिशन हवं स्टेजवर, म्हणून मला खरं म्हणजे इथे बसवलं. आणि लोकशाही उत्सवाला नाही म्हणणं हे मला फार कठीण झालं आणि म्हणून मी तयार झालेली आहे. म्हणून मी साहजिकच मला खूप अभ्यास करायला लागला आणि त्या अभ्यासासाठी मला संजयनीच मदत केली. त्यामुळे पहिल्यांदा आधी त्याचेच आभार फॉर्मली बोलायला पाहिजे. त्यामुळे मी त्यांचेच, आणि हे सगळं मुद्दाम मराठीत बोलते, इच्छा ही की प्रशांतजींना काही कळू नये. I hope you didn't understand it. Please don't explain it to him. मराठीतून का इंग्लिशमधून? आता तो बोलणारच आहे. इथून पुढे विषयाला हात घालताना इंग्रजीतूनच बोलणार आहे. हिंदीतून बोलायला भीती वाटते, कारण आधीचं पहिल्या वक्त्यांचं इतकं सुंदर हिंदी ऐकल्यानंतर पुणेरी हिंदी त्यांना ऐकवावं ही माझी हिंमत नाही. Actually, both the speakers have enlightened us, particularly Prashantji has enlightened us from his very practical experience in the Supreme Court, which probably none of us who is present here has ever been exposed. I have seen Supreme Court, but I have never got a chance to appear before the court. I have appeared before the Bombay High Court, but I don't want to share my experiences before the Bombay High Court. मेरी क्या हालत हो गई थी जब मैं कोर्ट में अपीयर हो गई थी. I appeared in 3 public interest litigation. I mean, think about 500 plus PILs against which 3, but I am just a teacher. So as a teacher I did some PILs, and then मेरी हालत क्या हो गई थी वो मुझे अभी नहीं शेयर करना चाहूँगी. काफ़ी फोरम में मैंने शेयर किया है, लेकिन नॉट टुडे. I learnt a lot today actually. So I do underline again my position as a student of law. So I have learnt a lot from Prashantji, and thank you very much for your very enlightened speech. And I think I am speaking on behalf of the entire audience. And I have no intention of summarizing what both the speakers have said, because आप बहुत ही intelligent बुद्धिमान audience हो, तो फिर से ये दोहराना कोई मतलब नहीं है उसमें. लेकिन जो भी मैं थोड़ी बहुत पढ़ाई करके आई हूँ उससे कुछ बातें आपके सामने ज़रूर रखना चाहूँगी. Sanjay has theorized quite a few points which were made by Bhushanji, and his own experience. He has, I think, probably he's the only one who has brought in this point with reference to understanding of the judicial activism and the kind of reforms that he has suggested. I feel as a student of law that it is very interesting to understand how Supreme Court responds to the situations when the issues are distinctly addressing public spaces against private spaces with reference to individuals. And there is a clear-cut understanding of any common person also who would read the judgments or whatever, even if reported in the social media, that when it comes to public spaces, then in that case the courts are very cautious, over-cautious if I can make the use, and particularly the current Supreme Court. Earlier Supreme Court, right from post-independence till I would say the beginning of 21st century, the situation was much, much better. So when I was full-fledged student and teacher, active teacher in the college, I had a very good time. And particularly when Professor Sathe was my teacher, I really enjoyed my learning of law, or constitutional law for that matter. Last decade is very, very disappointing. I'm glad that I'm no longer a teacher now, formally. But that doesn't mean that I cease to be a student of law, 1. 2, cease to be a responsible citizen of this country. So I certainly owe a lot to this country and to myself also, and of course to the citizen of this country. So on that background, I find these public spaces and private spaces, how they are shrinking at the hands of the judiciary, that needs to be understood. And About the emergency, people have said in this and that way. Sanjay's experience is from his own personal situation is altogether different, but I would definitely make a statement. I hope in audience there are reporters. I'm ready to go to jail. The statement that I'm going to make. Hope you will come there to give me some tiffin. In light of today's unproclaimed emergency, state's important wing, the judiciary, has very, very significant role to play. And we all, as a citizen of this democracy, look upon the judiciary that is our last hope. And that we always used to say. And I remember Professor Sathe's words on those lines. But however, currently, the situation is so worse that can we really depend on the Supreme Court also or not is a big question in my mind. And Prashantji concluded saying that now the ball is in our court. We, the civil society members, we have the responsibility to make everyone aware of their responsibilities and respond to our demands. And till that happens, probably, मला तर वाटतं ही क्रांतीच व्हायला हवी आता. आणि ती तशी जोपर्यंत होत नाही तोपर्यंत आपल्याला जे सन्मानाने जगायचं आहे, जे कॉन्स्टिट्यूशनने आपल्याला दिलेलं आहे, ते होईल की नाही याची शंका आपल्या मनात येते आहे. पण त्या शंकेला उत्तरही आपणच शोधली पाहिजेत. या संस्था आता आपल्यासाठी काही करतील असं आता सध्या तरी दिसत नाही आहे. We the people. Absolutely, you said it. What I have prepared is, I'm going to give you few cases in brief. I hope you will bear with me. If I cross my time, I know I'm presiding over, but now I request the organizers that if I cross my time, just send me a cheat 5 minutes more and then I'll stop. I'm going to start with little positive case. In spite of this negative criticism by all of us of the judicial activism, कुठेतरी लुकलुकणारे तारे दिसतात. आणि त्या ताऱ्यातली एक पहिली केस घेऊन मी सुरुवात करीन असं मला वाटतं. जोसेफ शाईन वर्सेस युनियन ऑफ इंडिया 2018 झालेली केस आहे, जिथे आपल्याला दिसतं की वन ऑफ द इसेन्शियल्स ऑफ मॅरेज इज लॉयल्टी. आणि ती लॉयल्टी is expected only to be of the wife. In a patriarchal society, what do you else expect? Adultery is an offense. This is not the time to explain the offense of adultery under section 497 of the Indian Penal Code. If somebody asks question, which I have not allowed myself, but maybe informally when it comes to, then in that case I can explain that. But otherwise one will find that adultery is an offense which can be committed only by one man against another man. Woman, though, is party to the offense, she never commits offense because she doesn't have capacity. Why she doesn't have capacity? Because she doesn't have sexual agency. She can't decide whether with whom I can have a sexual relation without anybody else other than the husband. That prerogative is only of the married man, husband. So only male persons can think of having sexual relationship with any other person than his own wife. Interesting. Chief Justice Chandrachud, Y.V. Chandrachud, who he then was, he is no longer. His son overturns his judgment. That's very interesting for me. So the current Chief Justice, then he was not the Chief Justice, he has not delivered the judgment, but he has overruled the judgment given by his father, stating that adultery is no longer offense. I wanted to discuss that judgment very much in detail, but because of short of time, I am just referring to that, the positive judgment which came from the Supreme Court declaring that that decision is no longer, or adultery is no longer offense. One rider to that. Case decided in 2018, 2023 Armed Forces Act, under which the case was referred to the Supreme Court again. Under Article 33, please correct me. Yes, under Article 33, there is a separate law under the Constitution of Article 33. There is a provision whereby separate laws for armed forces can be enacted. And under that law, adultery is an offense. However, it is gender neutral. Under the Indian Penal Code, it is not gender neutral. The offense is committed only by a man against a married man. However, that is not a situation under the Armed Forces Act. And therefore, the Armed Forces Act asks the court whether the same law that you have declared that adultery is no longer offense is applicable to the armed forces people also. And the Supreme Court said, I just give you the verdict, you decide on your own what you have to comment upon. The Supreme Court said, no. This being gender neutral law, it is not applicable to you. So adultery continues to be an offense for the armed forces people. I had to make a lot of comment on that also, but because of short of time, maybe we can have another time. लोकशाही उत्सवामध्ये अजून एकदा आपण डिस्कशन त्याच्यावरती ठेवूया. Bilkis Bano case was referred by Prashantji. I have reservation on that. He said good judgment. Of course, it's a good judgment, cancellation of the sentence which was given. And a friend of mine who was a judge who had given judgment in Bombay High Court, Justice Mridula Bhatkar, she had shared actually with me what had happened in the courtroom. This is not the time to share all that she had discussed with me. But the point is, why 15 days were given by the Supreme Court once the decision was given by the cancellation? And on the last day, 22nd was the last day of surrendering themselves. They surrendered themselves on 21st. Why 15 days? I presume myself in Bilkis Bano. I'm not emotionally making these statements. Please don't misunderstand me. I'm empathizing with Bilkis Bano. And had I been Bilkis Bano, how would I have faced those 15 days when those persons are not surrendering themselves? I could have been killed. And then they would have gone again to the court. I mean to the jail. Now, this is just, how the courts are responding to the situation. Why did the court feel like giving still 15 more days in spite of they were released on 15th August of 2022? Many questions for all kinds of cases which are coming up. We say these two cases I was looking at as a positive look लुकणारे तारे, पण त्याच्यात पण काही ना तरी काही गोची ठेवली. आर्म्ड फोर्सेस ॲक्ट ठेवलं आणि यांना 15 दिवस सुट्टी दिली अजून बाहेर मोकळं फिरायला. Now coming to the negative sides of the few more cases that I am going to talk about. In December 23, Lok Sabha expelled Mahua Moitra, MP from Parliament. She challenged expulsion immediately. 23rd December, expulsion took place. She challenged it on the 3rd January because there was a winter break to the Supreme Court. So immediately when the court resumed back, 3rd January, the matter came before the court. Court issued the notice to Lok Sabha Secretariat. And after giving time to file the replies, set the date in March. A prayer for interim relief was requested. And what was that prayer? That she be allowed to sit in the parliament without having right to vote. Now, but even that was denied. And budget session is expected in February, end of February. So she won't be able to attend even that. And then we know that the elections are due, and then the Lok Sabha will come to an end. So having hearing in the month of March is infructuous. It has no meaning. So by not doing something, by declaring that we will hear you has no meaning. So by doing, they are not doing something that they are expected to do. This is one case of Moitra. Another case which comes is of Election Commission Act. Just please correct me if I am wrong with reference to Election Commission Act. 2nd March 2023, Supreme Court gave a decision in Anup Baranwala's case whereby the court decided, the Supreme Court said that for appointment of election commissions, there should be a committee. And the committee should be Prime Minister, Opposition Leader and the Chief Justice of India. And to turn down that, the bill was proposed, and now, if I am correct, the bill has been passed. So it has become the law. And the law removes Chief Justice of India. And instead of that, the provision is made such that exclusive power goes with the Union Ministry. Interestingly, the search committee is headed by the Law Minister. And the Law Minister is supposed to prepare the panel. And then the panel would go to the Prime Minister and he will decide who that third person is to be appointed for. So obviously, and then furthermore, what the law says is that the full committee is not there for deciding who that third member and what the final decision would be for choosing the election commissioner, chief election commissioner, as well as the other commission members. It's not necessary that full committee should be there. So obviously we understand what is going to happen. Now the challenge was given to this provision in the Supreme Court. And what did the Supreme Court say? The Supreme Court said we will give hearing in the month of April. मी काही कॉमेंट करायची गरजच नाही आहे ना. इलेक्शन तुमच्या होऊनच जातात तिथे. म्हणजे या इलेक्शन्स आर गोइंग टू बी अकॉर्डिंग टू द प्रोव्हिजन्स ऑफ द न्यू लॉ. काय करताय सुप्रीम कोर्ट? कसली डेमोक्रेसी वाचवताय का ही आमची? म्हणजे ह्या इलेक्शन्समध्ये काय मला प्रश्न पडलाय, मी व्होटिंगला जाऊ का नको जाऊ? म्हणजे एकीकडे आय एम रिस्पॉन्सिबल सिटीजन, सो आय हॅव अ ड्युटी टू वोट. That's why I teach also. I used to teach the students that it's your duty to vote. सामाजिक संस्थेमध्ये कामं करताना पण we go and tell the people that you must vote. निगेटिव्ह वोटिंगची प्रोव्हिजन आता आली, निदान ते तरी करा म्हणून आम्ही सांगतो आहोत. अँड ऑन द अदर हँड द सुप्रीम कोर्ट इज ॲक्च्युअली टेकिंग अवे द राईट टू वोट फ्रॉम अस बाय गिव्हिंग सच काइंड ऑफ डिसिजन. म्हणजे ना हेल्पलेसनेस किती टोकापर्यंत आपला जाऊ शकतो असं वाटतं की वी जस्ट कांट डू एनिथिंग. म्हणजे ह्याच्यावरती काही कॉमेंट करावी अशी सिच्युएशनच नाही आहे असं सरळ सरळ दिसतं आहे. म्हणजे हे डिसिजन्स आर जस्ट सरप्रायझिंग. त्याच्या पलीकडे आपल्याला काही कॉमेंट करता येईल असं वाटतच नाही आहे. आणि म्हणून हे कॉन्स्टिट्युशनल कोर्ट्स हॅव अ रिस्पॉन्सिबिलिटी टू ॲक्ट ऑन टाईम. आणि acting on time by the constitutional court is so significant, and particularly in such emergency times, and which the courts are just refusing to act upon, and that creates a lot of worries for all of us who are concerned about our democracy, about which we and the entire world looks at India's largest democracy, which is being described all the time in this fashion. Another set of cases is with reference to the court's approach to the constitutional challenges with reference to the personal liberty of individuals. Reference was made by Prashantji, but I'm going little details. Bail orders, and I have reason to, because it's a Bhima Koregaon cases, and therefore I think it's necessary for us to understand what has happened with Navlakha and Raut's case, Mahesh Raut's case. Mahesh Raut's case, on merit, Bombay High Court grants bail. Now when it is on merit, then obviously you will find that he should have been released on bail. मला ना बोला असंच नाही वाटत आहे. काय म्हणतात त्याला, सेल्फ इम्पोज्ड रिस्ट्रिक्शन बाय द कोर्ट ऑन इट्स ओन ऑर्डर. आणि काय म्हणालं की त्या इन्व्हेस्टिगेटिव्ह एजन्सीला पुरेसा वेळ मिळावा, उनको समय ठीक तरह से मिलना चाहिए, इसलिए 8 दिन दे दिए, आप सुप्रीम कोर्ट में अपील कर सकते हो, तब तक स्टे ऑन द बेल ऑर्डर. हे म्हणजे काय इनोव्हेटिव्ह वे ऑफ गिव्हिंग ऑर्डर्स. म्हणजे ह्याला कोट अनकोट ज्युडिशियल ॲक्टिव्हिझम म्हणायचं का काय? सरांना वरती बसले तिथे त्यांना मी अजून प्रश्न विचारते संजय आता. इंटरेस्टिंगली द मॅटर वेंट इन अपील टू द सुप्रीम कोर्ट. आणि सुप्रीम कोर्ट म्हटलं की आम्हाला ऐकायला वेळच नाही आता. सो द मॅटर इज नॉट हर्ड आणि द मॅन इज इन बेल. म्हणजे अनलिमिटेड टाइम द बेल इज ऑन अँड द पर्सन इज सिटिंग इन द जेल. सेम इज द केस विथ नवलाखा ऑल्सो. द ओनली थिंग इज ही इज अंडर हाऊस अरेस्ट अँड दॅट्स वाय ही इज नॉट इन जेल. म्हणजे सो कॉल्ड जेल ही इज नॉट इन दॅट जेल, बट अनदर फॉर्म ऑफ जेल ही इज इन. Why should the Bombay High Court, म्हणजे पुढची वाक्य मला वाटतं तुम्हीच, मी डॉट म्हणते आणि सोडते. हे 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 अनएक्सप्लेनेबल आहे. आय मीन दिस काइंड ऑफ बिहेवियर वेन यू आर ऑन द बेसिस ऑफ मेरिट इफ यू डिसाईड द केस, आणि इतकं चांगलं जजमेंट ॲट वन पॉईंट तुम्ही देता, अँड ऑन द अदर हँड यू त्याचा सगळा आत्माच काढून घेता वेन यू आर डिलिव्हरिंग. सो these absolute, I mean these kind of approaches are actually astonishing for any person. ज्यांना काही लॉचं कळत नाही ना, एलचा सुद्धा कळत नाही लॉचा, त्यांना सुद्धा हे समजणार नाही की हे काय चाललंय इथे. ही सुप्रीम कोर्ट किंवा हायकोर्ट ज्यांच्यावरती कॉन्स्टिट्युशनल कोर्ट म्हणून काम करण्याची जबाबदारी आहे, ती लोक त्या पद्धतीने कामं करता आहेत का? आणि हे दिस इज हॅपनिंग रिसेंटली. हे ऑब्व्हियसली कोर्टाकडनं पूर्वी नक्की असं होत नव्हतं. शेवटची केस, आणि आय एम गोइंग टू स्टॉप, इट्स विथ रेफरन्स टू, आणि आता ही टिपिकल फेमिनिस्ट अँगलमधनं आपल्याला ही केस बघावी लागते, आर वर्सेस युनियन ऑफ इंडिया. आणि ह्या संदर्भामध्ये अतिशय सुंदर जजमेंट 23मध्येच आपल्याकडे दिलेली आहे. जस्टिस नागरत्नांनी जजमेंट दिलेलं आहे. ॲक्च्युली मला तिथपासून सुरुवात करायला आवडेल, बिफोर गोईंग टू द फॅक्ट्स ऑफ द केस विच हॅव बीन रिसेंटली डिसाइडेड. Justice Nagaratna in 2023 judgment had clearly observed that a fetus is dependent, I am going to read out, a fetus is dependent on the mother and cannot be recognized as an individual personality from that of the mother, as its very existence is owed to mother, and unquote. To compel pregnant woman to continue pregnancy for full term despite injury to her physical and mental health would violate her fundamental right under Article 21 and under Article 15(3). Very, very absolute clear statement. And Indian law as well as Indian jurisprudence has clearly pointed out with reference to pro-choice. Pro-choice, which means the right of the pregnant woman is respected. Indian jurisprudence has never touched upon, neither Indian law nor Indian jurisprudence has touched upon pro-life situation. So the fetus right is never being respected. What had happened in this case? A woman was pregnant and unfortunately her husband died, and she came to know after the death that she is pregnant, and she was undergoing such a mental trauma that she requested that abortion be performed. By the time she reached the hospital, AIMS, it's a Delhi case, she reached the hospital, she was 26 weeks pregnant. With the new law amendment, up to 24 weeks the termination of pregnancy is recognized. When she went before the court, I mean the entire her mental health assessment was done, she was admitted to the psychiatric ward, all those testings were completed, and the conclusive report was that she is under severe mental depression status. Delhi High Court gave the decision that pregnancy be terminated. Very clear-cut decision. Again, the court, what Sanjay was saying about recalling the judgment. The same Delhi High Court recalled the judgment. And what were the reasons given by? Because the AIM submitted before the court, actually the petitioner applied for execution of the order of the court, and AIM submitted the report that unless we get directions from the court about the status of fetus, we will not perform it. And about the status of fetus, the new argument was developed and then said that by this time the fetus is viable, can survive, and is without any abnormalities. And the focus was on abnormalities. Now in 2017 and 18, Ministry of Health and Family Welfare had issued guidelines stating down in which exceptional situations beyond 24 weeks also termination can be done. Of 5 conditions, 5 exceptions which are being laid down, only emphasis was given if fetus is abnormal. For which again we have another issue, why abnormality should be recognized only as a ground. So the disabled people have no right to come into existence in the world, as if we all are sitting people here are normal people. And what is normalcy is definitely to be challenged. I mean, that's apart from that argument. The other 4 exceptions were not taken into consideration at all. And the argument which was made by the state vehemently opposing the position taken by the court that it is the woman's health which is more, so pro-choice decision which was taken by the court itself was challenged by the state, and then the court, what it gave its own order was recalled, and then the termination was not recognized. So now women's bodies are controlled by society. So it's because it's a state, and that's why I'm saying it's a society is controlling the women's body. So she had to now deliver the baby. Now empathize with her and think of what will happen to her. husband is dead, she doesn't want the child, she's asking for abortion. On top of that, now she will have to deliver the child. The affidavit has been filed by the union government that we will place the child as soon as possible in adoption. Now, when the child is to be placed in adoption, what a kind of, again, the mental stress that woman, so the child is born, child is there, and now the child is to be given in adoption. All her remaining life she is going to suffer. So you just don't understand what kind of situation, the mental stress that woman is going to live. And she has tendency of committing suicide. That was also, her mental stress condition which is big. So I don't want to go further more in details, but the kind of personal liberty approach with reference to Article 21, which is very been, I initially read out Justice Nagaratna's judgment where she spells out so clearly. That is 23 judgment, and this judgment is coming in 24. So one can realize the way the Supreme Court is moving in which direction. And this is going to develop hereinafter. This precedent is going to create pro-life jurisprudence here in the context. So right-wing government in power, already we know what is happening and how the religious contentions is coming and how women's bodies are being treated. And that's why I said feminist jurisprudence needs to bring in over here, and we need to analyze such cases which are coming up. So the democracy is challenged, and even women's lives are also being challenged furthermore, which is very, very dangerous. So with these few comments, and तुमची सगळ्यांची क्षमा मागून, कारण प्रश्नोत्तरांना वेळ देता आला नाही, कारण खूप वेळ झालेला आहे म्हणून. थँक्यू व्हेरी मच टू ऑल ऑफ यू.